Good morning, friends. A jolly good morning, a hearty good morning to all of you. This is Bodhan Bhattacharya, Managing Partner, Bhattacharya and Associates, welcomes you from the web desk of Bhattacharya and Associates. As I had promised you earlier in my earlier videos, that I will be bringing up the topic of question of fact and question of law. How we can use these concepts of question of fact and question of law and how they are relevant, especially the topic of question of law, because question of law is something which you can work out to your advantage to a great extent. It can be used as a sword, an attacking tool. It can be used as a shield, a defensive tool. So it's like you can use it especially in the cases of writs and in cases of taxational writs as well. You have a big extent of relevance as far as this question of law and question of fact is concerned. Very plainly speaking, I will just sum up in 2 lines at first. Question of law is, rather question of fact is something by which you can raise any new point, any new ground, any new plea at any point of time. It's not needed that you have to take that plea at the trial level or before the, if you're practicing in the taxation arena. It doesn't mean that some grounds that you have forgotten to take in the assessment or in the appeal or in the revision, you have forgotten to take it. You can nudge it even at the writ stage before the writ court. Even against the first appeal, in the first appeal against a writ court's order, you can nudge a question of law. Even before the Honorable Supreme Court of India, there at the last limb, you can take it up as a question of law, any plea, but it has to be a question of law. Now, as far as question of fact is concerned, question of fact is something which has to be taken at the very outset. Question of fact, if you say today, if you plead that the shirt that was stolen from your cupboard was a yellow shirt, you maintain it throughout. And when the trial level and then thereafter in the first appeal, in the second appeal, the defense says, look, the shirt is basically yellow with 3 navy blue stripes. And you say, very well, that was my case. I said yellow shirt. Now I add shirt with 3 navy blue stripes. That becomes a question of fact which you cannot take subsequently. You should have said it at the very outset. You should have said your shirt was containing 3 navy blue stripes, the yellow shirt. So, but had it been a question of law, for example, if today in the grounds of appeal against an assessment order, if you say that you challenge it on merit and thereafter in the revision stage you take up that the assessment was barred by limitation, this is a new plea which you did not take in the appellate stage, or you take this plea at the writ court stage. Then nobody can say that you got debarred to take from plea because you have not taken it earlier. Because limitation is essentially a question of law. It involves something which has got to do with the legal question, substantive legal question. Now, cutting the matter short, I would like to refer to a presentation which I have made. I think that will clear the whole concept a bit more further. Be with me for the presentation, please. Look, what is the question of fact? This has been already described and held in 2007, 5th volume SCC, 669. Relevant paragraph is paragraph 16, page 675. An inference of fact from the recitals or contents of a document is a question of fact. But the legal effect of the terms of a document is a question of law. So an inference of fact from the recitals or contents of a document. Meaning, if today somebody says that Mr. A has contracted with Mr. B to supply a bag of grains. In ordinary trade parlance, bag of grains symbolizes, say, 100 kg of grains. Now, Mr. A proposed that proposed a bag of grains which he specially makes in his factory, which holds the bag of grain holds only 90 kilos of grains. But Mr. B, according to the ordinary trade parlance, he understood it as 100 kg of the grains. So there, the dispute is basically a factual dispute. Now, from this dispute, whether it's 100 kilogram or it's 90 kilogram, this is a factual question. But if you delve a bit more deep, the concept of consensus ad idem, the meeting of mind, that says what he has mentioned should be understood in common parlance. If the test is so made, or the question is so put, that whether the crux of the contract was 100 kg grain or 90 kg grain, it becomes a question of fact. But if I say whether the word bag is to be understood in accordance with the trade parlance, common trade practices, whether the word bag is to be interpreted in the light of common trade practices, then, my friends, it becomes a question of law. So you see how you can mold the situation, and you can take the advantage, how you can twist the precepts of pleading, and how you can reap benefit. You can ask that whether 100 kg is the eye of contract or 90 kg is the eye of contract. On a subsequent level, you cannot take this question because this is a question of fact. But even in the subsequent level, if you take this question up, say in the level of second appeal, then you take the question up that whether the term bag is to be understood in the common trade parlance, then it becomes a question of law, and it can be taken up at any stage. Now kindly look at the slide. An inference of fact from the recitals or contents of documents is a question of fact. So that was an inference of fact, 100 kg or 90 kg. But the legal effect of the terms of a document is a question of law. Now, what is the legal effect out here? Whether the word bag has to be used in common, has to be understood in common parlance or not. Whether the bag is to be read in as is used in the ordinary trade practices, or whether in view of the special fact that Mr. A manufactures grains in 90 kilogram bags, that knowledge will influence this contract. Then it becomes a question of law. Now on to the second slide. What is a question of law? The High Court should be satisfied that the case involves a substantial question of law. A question of law having a material bearing on the decision of the case will be a substantial question of law if it is not covered by any specific provision of law or settled legal principle emerging from a binding precedence and involves a debatable legal issue. Pausing here for a moment. So in 2006, 5th volume SCC, page 545, at paragraph 24, which spans from page 555 to 556, what the Supreme Court holds is essentially this, that the High Court should be satisfied that the case involves a question of law, or such question which can be debated on the question of law, where the legal principles are not yet certainly made, or where the provision where pat on the point provision is not there. Obviously you can ask a question whether this circumstance infringes a particular statute or not. That is also acceptable when the question of law is concerned, when we try to find out the question of law thereafter. A substantial question of law will also arise in contrary situation where the legal position is clear, as I said just now, either on account of express provisions of law or binding precedents, but the court below has decided the matter either ignoring or acting contrary to such legal principles. So in two cases, questions of law can arise when the law is unclear, there is no specific provision, there is a room for debate, and two, where the court below or the authorities below have acted in contravention to the settled principles of law. So there are two cases when we can infer a question of law. Number one, when there is a when the law is not settled, and there is a room for debate on the interpretation of the law. Second, when the law is settled, there is no room for debate, but the authorities or the lower court has acted in contravention to that established statutory law. So in these two cases, you can get the benefit of questions of law. Third slide. 2017 11th volume SCC first case, that is page number 1, paragraph 36 and 37 are relevant at page 18. This is the most important aspect. As I was saying, question of law can be taken up at any stage. Though the question was not raised before the High Court, the appellant need not be barred from raising this question before us, that is Honorable Supreme Court, because it is a pure and substantial question of law. So here again we come back and say that if the question is a question of law and has not been taken up before the High Court, the appellant is not barred to go before the Supreme Court and nudge the same issue out there. So that is the beauty of question of law, which I was trying to bring home from the very outset. Next. 2016 12th volume SCC 125 page, paragraph 7, page 129 is the relevant page. What does it say? While this question does not appear to have been raised before the State Administrative Tribunal, we call it SAT, it is a question of law and can therefore be raised at any point. Now kindly understand, while this question, so the question which was before their lordships in the Honorable Supreme Court, that question was never raised before the Honorable SAT, that is the State Administrative Tribunal, which relates to the service matters, where a person who is aggrieved with his service conditions against especially the state government, not especially, it's against the state government, they go for the remedy. So it's a question of law and can therefore be raised at any point of time. So that was another corroborative evidence, rather corroborative point. 1965 AIR Supreme Court 1325, this is, kindly look, this is a full bench judgment. What Honorable Supreme Court held? The question sought to be raised was a pure question of law and was not dependent on the determination of any question of fact. The first appellate court ought to have allowed it. Such pure questions of law are allowed for the first time at later stages too. So here the question was put before the first appellate court for the first time, but the first appellate court did not allow it. So in second appeal, the Honorable Supreme Court says that this question should have been allowed by the first appellate court. Why? Because this is a question of law, and question of law can be taken up even at later stages. So there we go, and that is the basic concept that I was talking about, that in question of fact you cannot take it up at a later stage. In question of law you can take it up at later stage. Now it is all about the skill of advocacy and court craft and the craft of giving relief to your client, by which you turn a question of fact into a question of law. As I have given certain examples in this video itself, you can rewind and you can once again get along with it. It's like a question of fact can be rephrased as a question of law. If you viewers are interested, you can go on with the video of mine regarding constructive resjudicata in taxation. There I have shown how a proper question of fact can be rephrased as a question of law. Achha, it's a very important aspect that I just came to my mind. The example that I have taken in that video of constructive resjudicata, that was an example of a live case. Now that live case we have already won. In order to save the privacy of the clients, I cannot give you the name and the case references, but this much I can tell you, that the proposition that I had propounded in that video of mine, that has been upheld by the Honorable West Bengal Taxation Tribunal, which happens to be functioning in coordinate jurisdiction of the Calcutta High Court single bench, right? So its decisions have the equal force that of the Calcutta High Court single bench decision. It settles the law, and it's a court of it's akin to a court of record. So that is something that where our concepts get ratified, and I'm very happy to share this with you. So now, as far as this question of law and question of fact is concerned, I guess we have already strived enough, and I have cleared the air up. So very well, bring on with the suggestions as you always do, and it's really encouraging to get all your supports. Till then, stay happy, be safe. Vande Mataram.